Is there some logistical issue, something like that? I think you give us a chance to peruse. It's become like a strategy that you give us this report just before the court sits, and then so we don't have time really
I'm
to.
sorry, yes, there is a delay on my part. Your Lordship may have it next week, Your Lordship.
We'll have it next week, yes. We'll use, because see, there are many things which you have to address as per the order of this court, last order. And you see, the thing is that, Mr. Advocate General, what's alarming is that now it's winter season, and because winter season, there is a spike in illegal mining and illegal trade. That is why. So all the more important that this season that you are all more proactive. In the summertime, then the trade doesn't happen. Then you can that is the thing. What do you say?
Your Lordship may have it on Tuesday, Tuesday or Monday.
11 Tuesday is a status report on behalf of the state government in compliance to the order dated 10/2/2025 has just been filed by the respondent stub. As the last order of this court contained many directions which were to be addressed. This matter after this matter next week on, what's the date? 4th. No, sorry. Now we're on the 6th, on 11th. On 11th March. Yes. For further orders, yes.
Item number 2.
Yes.
Pursuant to the last order, the private party was supposed to engage an advocate and file an affidavit.
Yes.
We have not got any affidavit. Maybe he's here.
You're allowed to file affidavit. Where's the affidavit?
My lord, I need 2 weeks time. Actually, my mother was had a bypass surgery, and I was not able to go through the case records properly.
You engage a counsel, you file it within, we're listing on 11th. Yes, okay. Make your prayer that time. Yes, you're Mr. Bhama.
Yes.
Mr. Bhama has appeared personally before the court today. Mr. Bhama, respondent 14, bracket, has appeared personally and subjects and submits that due to personal difficulty, the affidavit cannot be filed. This is the matter on 11th, together with PIL number 2/2022.
Obliged.
3.
3 is also connected, Lordship. It may come up on the same day.
You're there also. Yes, together with so and so on 11th.
My lord, one humble request, my lord. In each and every of the affidavits which I have filed on behalf of the company, we have stated and alleged that these PILs are not public interest litigation. These are private litigation by the local.
Put down affidavit. We'll examine.
Yes, my lord.
Obliged.
Yes. Not 11th. Why 13th? Inconvenient for you. Okay, 13th. Yes.
Any mention?
Whose phone is that?
Item number 1.
I am appearing for the petitioner, my lord.
Have you served notice on the respondent's
Yes.
number?
Please, my lord, we have served the notice. We have
Where is he? Oh, you are appearing, Dr. Mazika?
No, ma'am. Only for one.
After it's been filed also, but no appearance. Who is to appear with Mr. Pandey? You have any knowledge about this matter?
Lordship, I have received no instructions yet. Lordship.
So what are we to do? You give them an opportunity.
I'll inform them.
Yes, an affidavit indicating service on the respondents number 2, 3, and 4 has been filed on behalf of the petitioner. However, there's no appearance. No appearance on their behalf today. This is matter after. This is after 2 weeks to enable the appearance. Mr. Pandey is present in court, undertakes to inform the Standing Council of Income Tax at Guwahati. This accordingly on so yes. Interim
my
order.
lord, no.
Interim order. If any shall continue till next date. Yes.
Please, my lord.
Any mention?
Please, Lordship. Lordship, I beg to mention item 15 for the petitioner, the election petition, Lordship, where the issue of copies was contended heavily. I'm praying for a week's adjournment, Lordship, to complete my instructions because a little tricky situation.
See, you take proper instructions.
The last time I had
Like a
taken,
code repeat itself.
Lordship. The last time I
Like
had.
the old CG says, sounding like a broken record. Whether these election petitioners are really serious about pursuing
That they
their-
are, Lordship,
pursuing the
because-
election petition, or it's just wasting the court's time.
That they are, but here the issue is
you
that
see,
with
the thing is that you argue, then we have rendered judgments, all our interim matters. It takes all of court's time. If you're not interested in pursuing it, now it's already 25.
half the time is.
Half
We are
time is
interested,
gone.
Lordship. It's not the case, but we are still stuck with the issue of because some difficulty with the presentation. I'm praying for a week's time, Lordship, because
You won't give weeks time. You file an application.
I filed an adjournment application.
Who's the conducting counsel?
Lordship, myself, because earlier it was a different council. We have to.
Yes, seen a adjournment petition filed on behalf of the election petitioner. Stop adjournments allowed for the reasons stated therein. Just after 2 weeks, yes.
Lordship, I also have a similar prayer for item 18 on behalf of the
Item?
petition. 18, Lordship, 1-8.
18.
18, Lordship. 80 Bala Burman for the petitioner.
Yes.
No objection, Your Lordship.
Kindly grant 2 weeks, Lordship.
Yes. Okay.
Obliged.
Much obliged, Lordship.
Lordship, I also crave your Lordship's indulgence for mentioning item 21 and 22, Lordship.
Why wholesale mentioned?
Lordship, little
Yes,
difficult.
MS Marak.
Your Lordship, no objection, Your Lordship. Interim order may be continued, Your Lordship.
Well, both the matters.
Only 21 only, Lordship. There is an interim order.
After 2 weeks, interim orders will continue. And 22?
22 is, Lordship, it's a PT. It's a gratuity matter. I'm praying for only 1 week here, Lordship.
This is
Because some order has been passed, we are required to take instructions. I'm praying for a week's time, Lordship.
22. Mr. SDF please phones allowed 2 weeks time to obtain instructions. Yes.
Much obliged. Lordship.
Please, Your Lordship. My Lord, I beg to mention item number 16 on behalf of the state respondents. My Lord, the difficulty here is that there was an additional affidavit filed by the petitioner.
That was last
My Lord,
time,
yes,
same prayer.
we have
just to
received
show
we have
item
received
number
instruction, but
16.
it is not complete, my Lord. We have asked for further clarification, my Lord, to file our reply to the additional affidavit.
Further time is sought by MS Arkonil GA
1 to
to
5,
obtain
my Lord.
instructions on the additional
Your Honor.
affidavit filed by the petitioner. What is your name?
Sonia Langstay, sir.
Yes, just record her name also. Yes. Explain how the petition list after 1 week.
My Lord.
Please, Your Lordship. Lordship, yesterday there was a matter being contempt case number 3 2025, wherein the aggrieved party he appeared in person, being Mr. Louis Suting, where he had made a statement where my name came up, where he made a defamatory statement saying that I've been taking exorbitant legal fee.
He didn't say that. He said, I can't afford legal fees.
But Your Lordship, the video has gone viral, and I would pray that I've informed him as
point
well
that out.
to make a clarification, to recall, and also apologize for the statement because it's affecting my standing
Yes.
before the bar. So I've informed him, but I can't see him in the court, Your Lordship.
I mean, a formal application.
Your Lordship, I've just made a mention memo, and I've also refunded the money that he's
Now we'll
paid
do
to
one
me
thing.
as
You
well.
get that matter listed on Tuesday, since Monday I won't be here.
Tuesday, Your Lordship.
There's mentions made by MSP Sutuna for listing of contempt
Number 3, Your Lordship,
number 3
2025.
2025 on the ground that certain defamatory submissions have been made against her by the petitioner appeared in person. Stop. If the matter is serious in nature, let the matter be listed in the motion column on 11th.
Your Lordship.
11 yes, March. Yes.
I'll reply to Lordship. And Lordship, if the registry can inform him, because I've informed him, but he's not responding to the same.
Registry to take immediate steps to inform the petitioner.
I'll reply to Lordship.
Lordship, I beg to mention item number 23 also.
23.
Lordship. I have taken consent from the parties, Lordship. I humbly pray it may come after 3 weeks, Lordship.
Why 3 weeks?
Lordship, we need to seek some instruction from the petitioner, and now Ramzan.
You are appearing for whom, Mr. Datta?
I'm for the managing committee.
Which school is this?
Islamia Secondary School.
Here in Shillong?
Yes, inshallah.
2 weeks, okay.
Obliged. Please, Lordship, I beg to make mention item 20, Lordship. I'm praying on behalf of Respondent 6, Lordship.
Who you are appearing with this council?
No, Lordship, I'm from private respondent, Lordship. I'm from private respondent.
Of course, getting mixed up. Sometimes who's appearing to the council, we don't know. There's no fixed standing council. I've seen for some time now. Mr. Dingdo appears here, appeared, then Mr. Paul appeared.
No, Lordship, we are for a private respondent,
So
Lordship.
on another matter, he appeared to the council also.
Yes, Lordship. No matter.
Yes.
Objection, Your Lordship.
After 2 weeks.
Lordship.
Respondent 1 to 4.
You have 1 to 4. And you're for?
From Respondent 6, Lordship.
Mr. B. Sanitang, behalf of number 6, please, for please matter be adjourned for 2 weeks due to the absence of arguing senior counsel. Please allow this.
Liberalized, Lordship.
My lord, I beg to mention item number 19, 2 weeks time.
Yes. Yes, what's the matter about?
This non-registration of Nokma.
Where's
Of
Mr. Deb?
Donang
Yeah, with Mr. Deb.
Yes, Your Lordship.
You have no objection?
No objection, Your Lordship.
Okay, 2 weeks now. Yes,
Much obliged, Your Lordship.
call on.
Supplementary list item number 1.
My lord, this matter, what happened? The writ petitioner was offering a tuition, private tuition in Lapan in 2017. And there was one student who was studying at Lumbering Secondary School, taking tuition, and she lodged a complaint. In view of that, my lord, POCSO proceeding was started. And in the meantime, he was placed suspension in 2017. And this writ petitioner approached before this
Since
court.
2017?
2017, my lord. And on 10th January of this year, the Honorable High Court of this my lord, High Court has interfered with the suspension order directed for reinstatement. So on 12th, he was reinstated, pending the criminal trial.
When
And on
was
the
he reinstated?
My lord,
When was he reinstated?
reinstated on 12th February.
12th February.
On 12th February.
He
And
was suspended since?
suspended since 2017, my lord.
Okay.
2017. My lord, the judgment is page number 13.
Okay, no, doesn't matter, yes.
And thereafter, my lord, what happened? The criminal case also, he was completely acquitted, my lord, by order 11 Feb 2025.
11?
11 February
11 to
2025.
25.
Yes, he was acquitted.
1 day after he was acquitted.
Yes, he was acquitted.
Okay.
Thereafter, my lord, on the same day, the reinstatement order was passed by the
Where's that?
director, my lord. Page number 81.
Yeah.
My lord, when you see, in compliance to the Honorable High Court order, in the matter of the PWC number such, dated such and such, Shri Department is hereby reinstated in pending conclusion of criminal pending proceedings. My lord. On that date, my lord, he was already acquitted, but the director was not aware of. So after coming to know this, he approached the director that even criminal case was closed. So he requested them to reconsider, my lord.
Why?
Now,
Why? You're not impugning this order, right?
Oh, my lord, I'm not impugning. The next page, 82, my lord.
Oh,
On the same date, my lord.
flag, kini.
My lord, the next page, 82.
Yes.
My lord. I'm impugning this order. So on the same date, 12 February,
Okay.
he was transferred to Garo Hills, my lord. And one serving teacher, Elvira, was transferred to Jowai. Now he is admittedly, he was.
1 second. So, Trans Bagmara, Vice MT Alvira.
Yes.
Now, what is the connection between this lady teacher and him?
My lord, now according to the department, this lady is serving in Garo Hills. Now the petitioner who is serving in the Government Girls School Shillong transferred to Garo Hills, and this lady was asked to go to Jowai. And now the place where he is serving in Shillong, throughout, my lord, the contractual teacher is occupying the seat.
No, we don't understand what's the connection. We can understand if this other person is asked to come to Shillong and he goes to Bakmara. But he was to Bakmara and he goes to Jowai. What's the connection?
My lord, to accommodate, my lord, to send the writ petitioner to Tura. My lord. That is the purpose.
Yes.
If there is no vacancy, he cannot be sent to Tura. So in order to ensure that he can be sent to Tura, my lord, this lady has been transferred from Tura to Jowai. Solely for the purpose of...
She's serving me at Bakmara now.
My lord.
This lady is serving Bakmara.
No.
Where's this lady is serving this?
My lord, he was serving in, my lord, Bakmara. I'm sorry.
She was serving Bakmara.
She was serving in Bakmara.
Yeah,
and
you made
now
a statement there.
Yeah, madam.
in the petition?
But she's serving in Pakmara.
You made a statement.
It is there. Okay. And now, since the writ petition transferred to Pakmara, this lady is transferred to Juwai. Now, the purpose is to accommodate the writ petition in Pakmara. And in Shillong, my lord, the contractual teacher is occupying. Now, we requested for reconciliation, but the director, the next page 83, my lord, yesterday, he reiterated the same thing, my lord. But to rejoin the place of posting within 7 days from the date of issue.
Now you're affecting the posting of the teacher. You've not made her party also.
My lord, I'm not aggrieved with her. I'm not aggrieved with her, my lord.
She'll be aggrieved. She's affected.
My lord, if she is not aggrieved, if she is aggrieved to go to Juwai, my lord, perhaps she may.
You can't have that. You can't have that contingency.
No, my lord, I'm not seeking.
Person, suppose you get promoted and then another person you're going to supersede. But you have to make a party here. Also, this lady, she's serving Bhagwana, you can transfer to Juwai. And if interim orders are passed by this court,
it will not affect her.
It's adverse to her.
No, my lord, I'm serving in Shillong. Petitioner is serving in Shillong. So
we get it. Well, we get it. Now she's been favored. Whatever it is, she's accrued some rights under this transfer order. Correct? Then?
Therefore, my lord, my prayer is that I cannot be transferred to Pakmara since I'm serving in Shillong. And this lady is serving in Pakmara. So it will not affect her rights. My due respect.
Makes no sense.
My lord, kindly see the impugned order. It's a clear case of Malafide and Evangelicals, unable to accept my lord, the order passed by this court and the trial court.
You have me to make a party, yes.
My lord, transferable job, my lord. They are holding a transferable job. And moreover, my lord, lordship has also pointed out that this is a transfer of two teachers, my lord, government teachers. So basically, my lord, if one is accommodated, the other will be affected because it's an order that has come to, which has affected both parties. So, my lord, my prayer is that, my lord, the lady who will be affected with this intertransfer, my lord, she has to be make a party because right now we don't know, my lord, whether she have joined or not.
If that requirement, I may be allowed to implement as a party. But as of now, my lord, as of now, writ petitioner will be serving for less than one and a half
go and leave.
She'll be retiring, my lord.
The next misgender parties, we can't give you relief. But that way.
At least, my lord, the interim order may be given within next week itself.
In the absence of the private respondent, the other lady, my lord, I have objection to the stay order, my lord. We have to hear, my lord. She will be affected.
Council prays for allowed to implead for the necessary parties. Yes, you implead and then we'll see.
In that case, may such a will lordship permission may allow to withdraw this one and refile a fresh one.
Okay,
that
Mr.
save the time.
Due to defect in the writ petition, please be allowed to withdraw the same with liberty to file a fresh.
Yes.
So advise stop. Matter stands the support of withdrawal with liberty as played. Otherwise, you're affecting her. It'll be like it's actually a blatant worry personal justice. That's the thing.
Item number 2.
Yes.
Wait, please, Your Lordship. Lordship, as per the last order, we are supposed to file the objection, Your Lordship. But however, Your Lordship, because of Ramjan, Your Lordship, the petitioner he reached.
Ramjan started when yesterday.
Lordship, he reached this morning, Your Lordship. So we are in the process of filing. An advance copy has been served, Your Lordship.
Yes.
Oh, we have not. Madam, 15 days otherwise is over, madam. And they don't file the reply also, but after obtaining ex parte order.
You serve to the people who filed a miscase?
Yes, Your Lordship, we have.
They have filed a misapprehension, correct?
We filed.
We have served, Your Lordship.
Okay, we'll have on Tuesday. We'll close the matter. Mr. Kiri, I'm correct? Submits that the objection we find, of course, the day. Only this is a matter on Tuesday. This is a matter on Tuesday, yes, for the orders.
Daily list item number 1.
Yes.
My lord, I intend to withdraw the incident petition since the authorities are proposed.
We have civil remedies. Mr. Poshna.
Yes,
Mr.
yes,
Poshna today submits, please I will have to withdraw this incident application with liberty to take recourse to alternate remedy.
Thank you, to file fresh if needed.
Yes, so, to take recourse to alternate remedy and with liberty to file afresh, so advise. This matter is supposed to withdraw with liberty as per it.
Item number 2.
Yes. What is for
They are making submissions on the interim order and as well as request by the state to refer the matter to the judicial bench. On these 2 points, I'll make my submission.
Yes.
And I will refer your Lordship's order dated 27/2/2025, passed in miscellaneous WPC 32 of 2025. And particularly referred to paragraph 3, which contains the submissions made by learned advocate general. You got it.
Yes.
Mr. A. Kumar Lalit, AD for state respondent, has raised.
Where's Mr. Advocate General? He's not here.
Lordship, he was here a while back up.
Okay, Mr. Mishra, continue. Continue.
Lordship can take this at the end of the board, Lordship, since, if possible. If Lordship can take this matter then at the end of the board, Lordship, since.
Yes. I think he'll be online by the time he finishes. You take down submissions. Yes. Please continue.
Mr. A. Kumar Lalit, AD for the state respondents, has raised vehement objections and submits that interim order was passed in consideration of the fact that the state respondents were not taking any positive action at that point of time. Whereas the state government at this juncture is in contemplation of implementing the policy decision for creation of more central bonded warehouses. It further submits that the situation as such does not call for extension of the interim order. It further submits that prima facie satisfaction for grant of interim order has also not been substantiated by the petitioner. He therefore prays that extension be not granted and the matter be posted for hearing. With what his submissions, but with all respect to Advocate General, Learned Advocate General, these submissions, my lord, is unknown to law. When a person comes, my lord, against a threatened action, alleging that his rights are going to be infringed by the state, then, my lord, the state comes and says that time we were not taking, now we are going to take action, therefore interim order should not be extended, and that we should be allowed to infringe the right of the petitioner, and after we infringe, he can come back. He can come and he can challenge those orders by which his right has been infringed.
Yes.
This kind of submission, with all respect to Mr. Advocate General, is unknown to law, and I'll place 2 decisions on the point, my lord. Your Lordship, I'll first place DAV College versus State of Punjab. This is DAV College versus State of Punjab, 1971, 2 SCC 261. I will be referring to paragraph 5. This is a decision, my lord, by the Supreme Court in context of Article 32 of the Constitution, wherein the Honorable Supreme Court held that petitioner need not wait his right to be violated. He can come. And what kind of order has to be passed, my lord, when an action is, my lord, proposed against a threatened action, is that the government should be restored, should be restrained from infringing the rights of the petitioner if your Lordship is satisfied that the petitioner has made out a case and established his right at least prima facie. Now, your Lordship kindly come to paragraph 5.
See, I don't have the judgment with me. You did, Mr. Dr.
Even I haven't been given a copy of the.
The books are coming.
Advance copy we will not give, we will give.
Lordship, if
B261.
a copy of the judgments can be provided to.
It's okay, we don't need copy, just need citation beforehand. Or a laptop, whatever. No. This is whose list? Yes, DV College, yes. Yes, please read, Mr. Mishra.
My lord, paragraph 5 is at page 264.
Yes.
Your Lordship got
What
the
does it
order. See it?
What does it say? Para 5.
Did you get the receipt?
How nak keluar si Corona Brain? Otherwise,
I'm sorry, my lord, for the
I'll
inconvenience
just.
because we had from here.
Mana laptop jangan.
The wife was not.
Mana laptop jangan. "17 judgments. You give the list to that side. You give the list.
71. "71 2 SCC 261.
One second. I just
71.
one second. Just give me some time.
But, sorry.
Not something little time. Oh, that's okay. Citation. I don't usually use, okay. Nineteen 71. 71. 2 SEC.
261.
Yes.
Paragraph 5 is my lord.
Just give 1 second because the Wi-Fi thing's a bit.
I'm sorry, my lord. In fact,
That's fine.
should have been dropping.
That's fine.
Surprise.
Yes. Para 5. Yes, please read. A preliminary objection.
Objection
Yes.
has been urged on behalf of respondents that in a petition under Article 32, only where it is shown that there is violation of fundamental right and there is validity of the legislation or of legislative competence can be raised and determined. But in these cases, there is no violation of Article 14, 26, 29, and 30 of the Constitution, the petitioners ought not to be allowed to challenge the virus of the Act on the ground of competence of legislature to enact the impugned laws. This question has been dealt with fully in the benches, in the batch petition in which we have just pronounced judgment. Where we had also considered the contention of the learned Advocate General of Punjab, Shri Tarkunde, the learned counsel for Respondent number 2 in this behalf, and hence we do not propose again to reiterate the reasons in support of conclusion that a petition under Article 2 in which petitioner makes out a prima facie case of their fundamental right are either threatened, your Lordship kindly mark it, either threatened or violated, will be entertained by this court, and that it is not necessary for any person who considers himself to be aggrieved to wait till the actual threat has taken place. Now we have come before your Lordship against the threat. They say the threat is genuine, they are accepted, they have accepted that they are going to do it. And this they say don't extend the interim order, so allow them to infringe my right. And then I again come before the court. I can come against the threatened action. And that's what Supreme Court says, I need wait for my right to be actually violated.
Yes.
Now the second case is with regard to 226.
Which one is 2006? 2006.
2006.
6 SEC. Yes. 207. Yes, Mr. The question whether or not.
Yeah, the question whether or not cause of action wholly or in part for filing a writ petition has arisen within the territorial limits of any High Court has to be decided in the light of nature and character of the proceedings under Article 26 of the Constitution. In order to maintain a writ petitioner has to establish that a legal right claimed by him has prima facie either been infringed or is threatened to be infringed by the respondent within territorial limit of the court's jurisdiction, and such infringement may take place by causing him actual injury or threat thereof. We say we have right. They are threatening, my lord, to infringe my right.
Yes.
And now prima facie can show what is my right. I'll show enough. Should not take much time. Before that, if you permit me, I'll just, in few lines, I will sum up what is the fact of this. Should I begin? May I submit for you?
Yes. Yes, please.
My lord, the fact of the case, in nutshell, I'll submit, my lord. My lord, the state of Meghalaya took a policy decision to centralize import and distribution of Indian-made foreign liquor, beer, wine, etc., and to entrust import and distribution to a single entity. Single entity, my lord. I will show from their affidavit. So this was the policy decision of the government of Meghalaya to centralize the import and distribution of IMFL and entrust it to a single entity. And in order to meet that, they, my lord, amended Meghalaya excise rules, Meghalaya bonded warehouse rules. These amendments were brought in 2020. for creation of that single entity called CBW or Central Bonded Warehouse.
Yeah.
As a single identity, it was authorized to import and distribute IMFL, etc. Now, the object and scheme of 2020 amendments are, my lord, given by the government. It's a government case in an affidavit in opposition filed in 186 of 2021. We have enclosed it at page 151. 154, my lord. This is affidavit dated 28/9/2021.
Yes.
The relevant paragraph will be 26, 29, 30, 31 and 32, which my lords will find at page 166. 166 of the writ petition.
Yes. Yes.
And our paragraph your lordship has written 26, 29, 30, 31 and 32 are please. I'm placing 26, paragraph 26 at page 166.
Yes.
That it is submitted that the impugned amendment rules of 15/10/2020. This was when actually 15/10/2020 is a notification by which the rules were ratified. It is submitted that the impugned amendment rules of 15/10/2020 is a policy decision. Here in our case also they are saying it's policy decision. Their policy is being changed like they change their shirts. Of the state government aimed towards establishing central bonded warehouse for augmenting the overall efficiency of tax collection and augmenting the tax revenues. It is submitted that introduction of CBW creates a positive effect over each and every player involved in the supply chain of distribution of liquor. It is submitted that such policy decision is beyond any judicial review, as the same is undertaken by the state government after due consideration of various factors and does not suffer from any vice of arbitrariness. Now I'll take your lordship to 29. I'm just placing the relevant one. Otherwise, all these paragraphs are full of superlative about their creation of CBW. 29 I'm submitting, my lord, the next page. It is under the heading Ease in Tax Administration. Submitted that with the introduction of CBW, it would be easier for the government to exercise control and monitor one entity. This is single entity, my lord, the lordship will see. One entity in place of existing 45 and above bonded warehouses. Earlier, before this amendment, there were 45 bonded warehouses, my lord, which were importing and distributing liquors to the retailers. Now, these 45 will not import, but CBW will import as a single identity and distribute it to these bonded warehouses. So one entity, and it also serves as single point for collection of duty and fee, etc. levied by the government, thus helping in plugging the revenue leakage, if any, in the system. The CBW is governed by all extant Meghalaya bonded warehouse use under the supervision and control of Excise Department. Right from importing all types of liquor to issue and transportation to different bonded warehouses all over the state. So this single entity will import. This is their pleaded case. 30th. The creation of CBW is to facilitate availability of wider range of brands to consumers of the state as per their rights and preferences, and to enable the bonded warehouse with lesser financial capabilities. to compete with the big players on the level playing field. It also submitted that CVW, due to economies of scale, I don't understand this, would be in a better position to cater
This is
the demand.
this is an economic term here, in economics. Yes.
In the state, irrespective of their location. The owners of transportation and delivery of goods to bonded warehouses across the state is again on CVW, an investment on account of payment of prepaid advertisement duties, fees, etc. in addition to.
So you mean to say that this central bonded warehouse, these other bonded warehouses order and it's delivered to their bonded warehouse?
Yes, doorstep delivery.
It's like online.
Might not be imported.
It's not exactly
bonded warehouse.
It's like an online system. I mean, you just order and it comes.
Yes, and they place order through. It comes through excise department.
Okay.
Their order comes to us through excise department.
Or through excise department. But then that's fine. I was wondering about that. You know. So anyway, so that leakage thing.
Order comes to excise department. Indent, they call it indent. Indent comes from excise department.
Yes.
What they are saying is, if there were 45 bonded warehouses, there were leakage of revenue. Now we have only single entity. That is how we have entrusted CVW or created CVW.
Yes.
31 I am reading. That with the CVW in place, the revenue stream to the government would in no way be compromised. Rather, by levying license fee, government tends to gain, and not only that, monitoring a single entity, your lordship will kindly mark it, single entity would be any day, any time, easier for the government to check on possible causes of revenue leakage and come up with timely remedial measures to address and fix the same. Now 32. The government neither intends nor give up any kind of control when it comes to import, export, transport, manufacture, sale or possession of intoxicating liquors by creating CVW. Rather, it establishes to serve as single point reference to bring about progressive change in supply chain, wage automation and integration with end point of sale, in addition to getting timely inputs to study the market trend across the brand to amend or introduce excise policies in the line with the changing times and market, acting as a catalyst for overall growth of industry, leading to growth in our excise revenue, which is largely used to fund various welfare and development schemes. Now, your lordship has seen this, the CVW was created for the purpose mentioned by the state. I have just placed before your lordship. Now, after this, they issued NIT. The NIT was issued by them. When I go to the rights, otherwise there will be petition, then I will place the. When the petitioner applied, submitted its tender, my lord, and he was awarded the contract to operate central bonded warehouse. Now, meanwhile, my lord, the constitutional validity of the Amendment Rules 2020 was challenged by one International Spirit and Wine Association, which is registered as WPC 186 of 2021. There, my lord, constitutional validity is challenged. In our case, we are challenging their threatened action for creation of additional CVW. Now, during pendency, efforts were made, my lord, to compromise the issues.
In the other matter?
In the other matter, because the division bench also wanted that the party should compromise. So I am told there was a very good atmosphere in the court, and then and efforts were made to compromise. Your lordship will gather that if your lordship turns to page 123 of my report. 123, one order and please.
Yes.
Everybody wanted a compromise. Annexure 9, page 123. Page
Yes.
1, 2, 3.
Yes, I've got it. Yes. Order dated 27/9/22.
That's right, my lord. It is suggested both by the state and the central bonded warehouse set up in the state that the apprehension and perceived problem referred by the petitioner can best be addressed by negotiation. Indeed, central bonded warehouse submits that several individual IMFL manufacturers have their problems resolved pursuant to discussion. Since the state has taken the lead and indicated that a senior officer of the state will be deputed to meet the representative of the petitioners association to sort out the matter, the petitioner do not immediately press for hearing in the hope that their genuine fear would be allayed and their concern will be taken care of. It is hoped that the initial meeting is held in course of this week, etc., etc. This is just an effort, my lord. Then the next one, my lord, if your lordship will see, order dated at page 131, order dated 29/8/2023, 131.
Yes.
It does not appear to this court that the state is serious in allaying the apprehension of the petitioner or attending to the several anomalies that have been indicated in the recent record order passed in the matter. Though the state was required positively to address the issue to come up with modification of a scheme suggestion that would bring about level playing field. My lord, may I pause here for a second? My lord, this level playing field emanates from Article 19(1)(g), and it will apply, my lord, for competition, my lord, if two parties, more than one party is competing for any state largesses, then, my lord, there has to be level playing field so that all the participants have equal chance of succeeding. In the year level playing field, of course, the court has said, I will make my submission, I'm appearing in that case also. Level playing field, my lord, is not applicable because the manufacturers are not party. They never submitted their tender. Level playing field, what they mean is that earlier we had 45 customers, they were buying from us, now only one. So therefore he will dictate term. So earlier you were dictating term. This kind of argument for challenging constitutional violence of a provision is unknown to law. So I was on second paragraph at page 132. The state seeks further time. It is imperative that the state's modified scheme is finalized and produced within next 10 days. And it is made clear that as long as the state can demonstrate the creation of a centralized agency do not enable such agency to differently treat manufacturers, whether by conferring, etc., not important. Now, what the state did, my lord, they constituted a committee. And the committee suggested, committee did not find any fault with the central bonded warehouse working, but they said that create one more additional. And on that basis, they took the decision, and that decision, my lord, I have given, it is at page 135, in paragraph 3 and 4 of their affidavit, the government affidavit.
Yes.
Paragraph 3 is that it is at page 136.
Yes.
That it is submitted to the government of Meghalaya in furtherance of recommendations of the technical committee has decided to create additional.
Yes.
Decided to create additional central bonded warehouse in the state of Meghalaya. A copy of the recommendation of the technical committee is so and so. The additional CBW would reduce any apprehension of favoritism and provide level playing field to all stakeholders. So, what level playing field that I will make my submission there, my lord.
Yes.
Now, this, my lord, action is a threat to our rights, which is, my lord, there under the Constitution, under the 2020 amendment rules, as well as the contract matter, and the threatened action is also violative of Article of Doctrine of Promissory Estoppel. And few lines I will make my submissions.
Only one thing, Mr. Mishra, before we proceed. Are we hearing an interim matter or are we hearing it finally?
My Lord, I'm praying for a interim order.
Extension of the stay. Okay.
And,
okay.
Yes.
Then we limit
And
ourselves to that.
then,
Yes.
my Lord, and I'm also saying
Yes.
that reference to a division bench, my Lord, it cannot be asked as a matter of right. And I have, my Lord, two decisions. If you not
Right.
permit me, I will.
Let us go to that. Yes. Reference to
Yes.
DB, not a matter of right. Yes.
Yes. My Lord, Your Lordship, first of all, my Lord, the matter pending before the division bench and the matter which is pending before Your Lordship are not similar matters.
Yes. That we would like to address. Yes.
Yes. Paragraph 8 of our affidavit in reply, which is at 43 of the paper book. 40 of the paper book.
Affidavit reply.
Yes, my reply, my Lord, to their affidavit in opposition dated 10/12/2024.
Yes. Yes.
My Lord, if Your Lordship turn to page 44, I have quoted the prayer which is made in WPC 186 of 2020.
At 44.
Yeah, page 44 of the paper book, madam. This is how we got from the registry, madam.
Yes, okay, 44, yes. Yes.
You can refer to the internal page.
Internal page 4.
Page 5.
Okay, 5, okay, yes.
Madam, 4 is paragraph 8. It continues, and I am at page 5,
Yes.
internal page. The prayer, last line I am reading, madam. The prayer mentioned in WPC 186 of 2021 are being reproduced here.
Yes.
Issue a writ, order or direction in the nature of a writ of certiorari or any other writs, orders or directions quashing Rule 2A of 44 of the Meghalaya Bonded Warehouse Rules inserted by clause 2 and 3 of notification dated so-and-so, bearing so-and-so by the respondent 2, being ultra-virus, the provision of the Constitution of India and Meghalaya Excise Act. Issue writ, order or direction in the nature of writ of certiorari or any other writ, order or direction quashing clause 2, 3 and 4 of the notification dated 15/10/2020 bearing number so-and-so, amending Meghalaya Excise Rules as adopted, being ultra-virus, the provision of the Constitution of India and Meghalaya Excise Act. Issue any other writ, order or directions in favor of the petitioner as the Honorable Court may deem fit and proper in the interest of justice. Whereas, in the present writ petition, that is writ WPC 430 of 2024, the present one, the petitioner is seeking to set aside or quash the decision of the government of Meghalaya to create additional central warehouses and to restrain the state of Meghalaya from creating additional central bonded warehouses. The prayer made in WPC 430 2024 is reproduced below. Setting aside quashing the decision of the government of Meghalaya to create additional central bonded warehouse. B. Further, be pleased to restrain the government of Meghalaya from creating additional central bonded warehouse and on such cause or cause being shown, these are there, and prayer interim is, in the interim pending disposal of the writ petition, this Honorable Court may be pleased to pass order or directions restraining the respondent from giving effect to the decision of the government of Meghalaya to create central bonded warehouse, and further be pleased to restrain the government of Meghalaya from creating additional central bonded warehouse during pendency of this instance petition. My Lord, pursuant to this, your lordships granted, the lordship granted an order of status quo on 29/11/2024, which is continuing till date.
Yes.
Now, I will establish my right, if the lordship so desires right now. And I'm prepared for full hearing right now. Because unless your Lordship will have to hold that I don't have a right, and then your Lordship will say that therefore the interim order is vacated. But they also have said that we have not been able to establish our right. We establish our right, that is how your Lordship has granted.
Yes.
Now, there are two decisions, my lord, on the point.
Yes.
My lord, the first is Gopal Kumar B. Nair, 2014, 5 SCC, page 800. Paragraph 12, page 805. Placement. Reference of a case to a larger bench necessarily has to be for reconsideration of the principle of law on which the case has been decided, and not on the merit of the decision. The decision rendered by any bench is final inter partes. Subject to power of review and curative power, any other view would have the effect of conferring same kind of appellate power on the larger bench of this court, which cannot be counted. If your Lordship permit me, I'll just tell your Lordship one incident. The then Chief Justice of Guwahati High Court, Justice Chalmeshwar, he was, my lord, given some order by the division bench of Andhra Pradesh, and he was furious. And then he wrote that single bench of a High Court is not subordinate to the division bench. I'll just give the reference, you will see. This is AIR 2002, Andhra Pradesh, page 220. Page 220. Your Lordship will see the tenure of Lordship has seen Justice Chalmeshwar.
Yes.
He used to conduct. And he told me, while I was arguing a case, he told me. So even division bench, my lord, they are very careful. They don't say we direct the single judge to do this, to do that. No. Then we make a request, always. So therefore, my lord, they are not that way, my lord, superior court. And your Lordship cannot refer it on merit. Your Lordship is competent enough and has the jurisdiction to decide. Now the second case, this is the last on this, is Shah Fashion. Dr. Shah Fashion and others versus Union of India, 2024 SCC. 2024 SCC. I'll be referring paragraph 90, page 1. Paragraph 19, my lord, your Lordship will get at page 10.
Yes.
When a decision is rendered by this court,
yes. Para?
When a decision, paragraph 19, 19, page 10.
Yes, yes.
When a decision is rendered by this court, it acquires a reliance interest and the society organizes itself based on present legal order. When substantial judicial time and resources are spent on reference, the same would not be made in a casual and cavalier manner. So it is not available for asking, because the state wants it to be, your lordship, to refer it to division bench, your lordship will not. It is only when a proposition is contradicted by a subsequent judgment of the same bench, or it is shown that proposition laid down has become unworkable or contrary to a well-established principle, that a reference will be made to a larger bench. Then they are referring to another case I did not. So all that I'm saying is the referring to a larger bench is a very serious question and cannot be done in a casual and cavalier manner. That's what the Supreme Court says.
Yes.
So my assumption would be that what is pending before the division bench is not similar, and there is no other reason for your lordships, with all respect, to refer it to the division bench.
Right.
Now, my lord, if your lordship permit me, I will just briefly tell my lord what are my rights. Briefly. Your lordship will kindly see Meghalaya Excise 3rd Amendment, Rules 2020. Annexure 7, page 9.
Annexure 7.
Annexure 7, page 79 of the writ.
Yes.
In the principal rule for existing Rule 4A, the following shall be substituted. Central bonded warehouse shall apply import permit on liquor allowed for canteen license based on quarterly allotment on payment of import pass fee, transport fee, literacy fee, advertisement fees at the rate applicable to the canteen as notified by the government from time to time at the end of every quarter of the last so-and-so, so-and-so. So I have the right to apply for the permit to import the liquor, IMF. Then your lordship will kindly turn to page 76 of my writ. 76.
Yes.
Well, 44(1). A license.
Yes. To establish.
A license to establish and work a central bonded warehouse in the designated area on prior approval of the government shall be issued by Commissioner of Excise. This has been given to us, and your lordship will see it. And the license was given to us below, which I'm sorry, I'll just give you. Your lordship will find at page 38. 38. Lordship.
Yes.
Annexure 3.
Yes.
Measures so-and-so central warehouse
License to construct, yes.
So is hereby authorized by the Excise Commissioner Meghalaya to work a central bonded warehouse at 9th mile so-and-so for deposit and storage of foreign liquor, which or such spirit as be permitted by the Excise Commission from time to time. So this license was issued to us. Now I will take your lordship and lordship come to paragraph page 76 again. Once the license is given to us, what is our right?
Yeah.
Well, I will read the third. The second one is regarding selection. So I have already been selected. 3 is, my lord, the base fee of license to operate a central bonded warehouse. Your lordship will mark it. A central bonded warehouse shall be 1 crore 50 lakhs only annually, or as fixed by the government from time to time. 4. The tenure of the license shall be for 10 years. Why? Because a lot of money is required to be invested. That I will get from this only, from the rule only. 10 years, the Commissioner of Excise, however, reserves the right to extend the period of tenure with prior approval of the state government for any additional period after expiry of the terms of license at the same or revised terms and conditions as awarded. So these are statutory provisions which has been incorporated in the tender document. This is part of the tender document and it's a contract now. Then your Lordship will see the central bonded warehouse shall deposit a security deposit of an amount equivalent to awarded annual license fee for a period of 10 years. So 10 years we have to give ballot at the rate of 1 crore 50 lakhs placed to the Commissioner, which shall be forfeited in case of failure to abide by the condition as laid down in the license or any breach of Meghalaya Excise Act or the rules. Then, my lord, I will take your lordships to 6. The central bonded warehouse shall operate on a plot of land measuring not less than 1,50,000 square feet, which is fully developed for immediate use and duly surveyed and certified by the Deputy Commissioner. So I have to, my lord, provide this land. Then central bonded warehouse must construct a warehouse or go down having capacity to hold at least 6 lakhs cases of IMFL. How huge it will be, I can only imagine. Beer, wine, BIO, etc. within a period of 4 months from the date of issue of license, along with building safety certification from PWB building. Central bonded warehouse shall be eligible to supply only to the bonded warehouses located in the state, within the state. Then, central bonded warehouse shall have the capacity to supply and deliver registered brand of IMFL to the bonded warehouses within 45 days for the goods produced in the state and 60 days for the goods imported from outside. 2-3 more minutes, I will not take much of it. Central bonded warehouse shall have a minimum stock of all types of brand for 3 months at any point of time so that continuous regular supply can be maintained for all bonded warehouses throughout the state. And the central bonded warehouse must be operational within 4 months from the date of issue of license. Then 14 minutes. On commencement of the central bonded warehouse, the bonded warehouse shall lift all the liquors from the central bonded warehouse against the import permit issued by the Commissioner of Excise and cease to import directly from the company or the bottling plants. And my right flows from here. I have spent so much money and I have been given a license for 10 years. And I have deposited money, I have deposited an amount equivalent to 10 years. My right flows from here. Then, I'll now take your lordship through the tender. Your lordship see the tender at page 29, annexure 1. This was placed on the first day when I moved.
Yes.
Commissioner of Excise Meghalaya Shillong invites tender from interesting individual partnership firm company dealing in liquor trade within the state of Meghalaya for operating a central bonded warehouse for supply of IMFL beer wine to all bonded warehouses. I have placed 4414 that all bonded warehouse located in the state shall buy from us, central bonded warehouse, because the government took policy decision to have a single entity, my lord, to import and distribute the IMFL. It is in person that this has been issued. A central warehouse supply IMFL beer wine to all bonded warehouse located in the state of Meghalaya up to so. So this was the tender. Then tender document, my lord, will find at the next page, annexure 2. Tender document. There are just few relevant clauses I will place. My lord, scope of the tender. notice inviting tender is issued for operating a central bonded warehouse. If my lord remembers, your lordship pointedly asked the Advocate General regarding the first one, why it is a central warehouse? That means there is only one central warehouse. He says that is tender and all that. I will show the letter of intent where the same thing is mentioned. I'm placing it for. The notice inviting tender is issued for operating a central bonded warehouse for supply of IMFL beer, wine to all bonded warehouses located in the state of Meghalaya on procurement, etc. So this tender was for operating a central bonded warehouse which will have right to, my lord, supply to all the bonded warehouse located in the state. Then next I'll come to earnest money. Earnest money deposit of rupees 50 lakhs only for operating a central bonded warehouse for supply of IMFL, etc. to all bonded warehouse located in the state. Time and again they are saying, so this is my right. Then your lordship will come to the special terms and conditions, which your lordship will find at page 34. 34. I'll place serial number 3.
Yes.
I've already placed.
Yes, can a contract with 10 years.
Yeah, 10 years. So these are statutory contracts, and there are 7 clauses which are statutory. 7 clauses. So these are the statutory contract, not an ordinary contract.
Yes.
On this, my lord, statutory contract, I will place a decision, but before that, I want to place, my lord, the letter of intent. How it was granted to us. Your lordship will kindly turn to page 59. Page 59. I'm
59?
sorry, page
No.
50 of the AR, our additional affidavit. Affidavit in reply. Internal will be, my lord, 20. This is addressed to us, my lord. Letter of intent for operating a central warehouse in the state. We are pleased to issue this letter of intent for operating a central bonded warehouse in the state pursuant to the issue of government letter dated so-and-so, allowing for operating a central warehouse in the state for supply of IMFL, beer, wine, BIO, etc. to all bonded warehouses located in the state of Meghalaya. With effect from financial year 2021-22 as per terms and conditions, and you are accordingly hereby required to. Now this deposit, madam. Deposit an initial fee of rupees 1 crore 65 lakhs for a year so and so. Thereafter increase of so and so so and so. Then 2, my lord, just 2 lines. Deposit an amount equal to the license fee quoted for the central bonded warehouse duly accepted by the government as security, either in the form of fixed deposit, call deposit, or bank guarantee from nationalized bank. In favor of Commissioner Excise for 10 years. We have given this also. And they said that we have no right.
Right.
There's just one decision, just one decision, small decision. This is 2000 volume 3 SCC 379. This is India Thermal Power.
Yes.
Page will be, my lord, paragraph is 11, my lord, at page 386, the relevant, and I'll read just 6 lines. at page 387 is the relevant part of paragraph 11, which I am placing before your lordship. 387, if your lordship, just 2 lines above Placitum B, my lord, on the left side.
Merely because.
Merely because a contract is entered into in exercise of an enabling power conferred by the statute, that by itself cannot render a contract contract. If there is a statute says that you enter into contract, that contract will not be statutory. If entering into a contract containing prescribed terms and conditions is must under the statute, that contract becomes a statutory contract.
Yeah.
If a contract incorporates certain terms and conditions in it which are statutory, then the said contract to that extent is statutory. I have right, my lords, under the statutory contract, subject to my fulfilling all conditions, to run this central warehouse for 10 years. And my lord, with all respect to my lord, young Advocate General, he referred to my lord license, which I had placed before your lordship, page 38. He referred and made some submission. I'll first refer and then I'll make the submission. 38 is the license, and he referred to clause 18. Clause 18.
Yes.
He has referred, my lord, I'll place it 18 at page 40.
Yes.
That the license shall not be entitled, licensees shall not be entitled to any compensation for cancelling his license and abolition of the central bonded warehouse as a result of any policy of the government or any other reasons. The government in a democratic setup has become so powerful that they will do anything they want to do. My lord, I need not tell your lordship that way back in 1215, there was a treaty between King John of England and his baron, known as Magna Carta.
Yes.
Which, my lord, provided that king will be subservient to law, not above law. I have asked my learned friends will place, my lord, Magna Carta. I don't know if they have a copy.
Yes.
But you must be aware, because
yes. Historical perspective, very much, yes.
In June 1215, and was the first document to put into writing the principle that king and his government was not above law. It sought to prevent the king from exploiting his power and place limits on the royal authority by establishing law as a power in itself. I have read somewhere, my lord, that in the Indian context, part 3 of the constitution is Magna Carta. The government cannot act arbitrarily. The lordships are aware of Menka Gandhi and then E.P. Royappa case. How the Supreme Court has dealt with arbitrariness in the government power.
Yes.
So therefore, my lord, it is to say that government will cancel and we will not have any remedy is not correct.
No, that is all subject to judicial review. They will say that. That's what they're saying. So they will seek to maintain that. Yes.
Yeah.
Yes.
Now, my lord, on promissory estoppel, I'll just touch it because there seems to be a lot of confusion. I have seen their affidavit in opposition. They say, where is the promise? Those things are a little confusing. My lord, the state, if the state makes a representation to any person, to sitting people, or any person, the state will be bound to honor that representation. That is what is promissory estoppel. In my lord, I have read Kobe versus Kobe in England, UK. My lord, the law was that you can use promissory estoppel as a shield, not as a sword. Meaning thereby, you can only use it as a defense, not as a sword. But in our case, it is different. We can use it as a sword. And I'll place some decisions, and those are well-known decisions. Now, I have already placed, my lord, the representation that the government has made. The government has made representation by amending Meghalaya Bonded Warehouse Amendment Rules 2020, Meghalaya Excise Third Amendment Rules 2020, then tender notice dated 17/11/2021, tender documents dated 18/11/2020, letter of intent dated 23/2021, and the last not the least, the affidavit in opposition of the state government dated 28/9/2021, filed in WPC 186 of 2021, which I have placed before. These are the representation made, and we have altered our position. And therefore, the government cannot resign that we will establish many other bonded warehouses we have a right to do. No, you don't have. Now the decision that I will place, the first decision is in fact the leading, first they say Bodila Padampar, but the leading decision according to me is Indo-Afghan Agency. That is, we have given Manupatra, and another will give her. I'll place, my lord, three small paragraphs. The fact which give, paragraph 1 I am placing. The fact which give rise to appeal, number so and so, are these. The Textile Commissioner published on October 10, 1962, a scheme called Export Promotion Scheme, providing incentive to exporter of woolen goods. The scheme was extended by a trade notice dated January 1st, 1963 to export.
Yes.
Of woolen goods to Afghanistan, Messrs. Indo-Afghan Agency, hereinafter called the Respondent, a firm dealing in woolen goods at Amritsar exporter to Afghanistan in September 1963. Woolen goods of FOB, it's freight on board, my lord. Value of 5 lakh something. The Deputy Director in the Office of the Textile Commissioner, Bombay, issued to the respondent an import entitlement certificate of 1,99,000 only. Representation made by the respondent to the Deputy Director and to the Union Government that they be granted import entitlement certificate for full FOB value of the goods exported failed to produce any response. That's how they have filed the petition. Now, your lordship will come to paragraph 31.
Bound to carry the promise. Yes.
This case is, in our judgment, a clear authority, referring to some foreign judgment, clear authority that even though the case does not fall within the term of section 115 of the Evidence Act, it is still open to a party who has acted on representation made by the government to claim that the government shall be bound to carry on promise made by it, even though the promise is not recorded in a formal contract as required by the Constitution. If representation is made, that is enough. Then, my lord, your lordship will turn to paragraph 35.
Yes.
Under our jurisprudence, the government is not exempt from liability to carry out the representation made by it as to its future conduct, and it cannot, on the same undefined and undisclosed ground of necessity or expediency, fail to carry out the promise solemnly made by it, nor claim to be a judge of its own obligation to the citizen on ex parte appraisal of the circumstances in which obligation has arisen. We agree with the High Court that impugn order passed by the Textile Commissioner and confirmed by the central government imposing cut in the import entitlement by the respondents should be set aside and quashed, and that the Transport Textile Commissioner and the Joint Chief Controller of Import and Export be directed to issue to the respondent import certificate for a total amount of 100% of FOB value of the goods exported by them, unless there is some decision which falls within clause 10 of the scheme in question. Therefore, the government is bound by the representation that it made to the citizen or any person. Now, my lord, on the question of, again, promise not recorded, I'll my lord, place 1990, Ashok Kumar Maheshwari, 1998 to SCC 502. 502.
Yes, para 8.
Para 8. Doctrine of promissory estoppel has been evolved by the courts on principles of equity to avoid injustice. Estoppel in a black law dictionary is indicated to mean that a party is prevented by its own act from claiming a right to the detriment of other party who was entitled to rely on such conduct and acted accordingly. Section 115 of the Evidence Act is also more or less couched in the language which conveys the same expression. Promissory estoppel is defined in Black Law Dictionary as, quote, that which arises when there is a promise which promises should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promise, and which does not induce such action or forbearance, and such promise is binding if injustice can be avoided only by enforcement of it. Just one more paragraph. These definitions in Black Law Dictionary, which are based on the decided cases, indicate that before the rule of promissory estoppel can be invoked, it has to be shown that there was a declaration or promise made which induced the party to whom the promise was made to alter his position to his disadvantage. Now your lordship will go to 16. I have shown, my lord, how the event took place. They first took the policy decision, which has been mentioned in paragraph 26 to 32 of the affidavit in opposition filed by the government. And thereafter, they amended the rules in 2020. After that, they issued the tender. Then tender was submitted, it was considered, and the contract was awarded. The letter of intent was issued, and the license was also issued. Now, 16 I will read. So far as this court is concerned, it invoked doctrine in Union of India versus Anglo-Afghan Agency. I have just placed it for adoption, Anglo-Afghan, in which it was inter alia laid down that even though the case would not fall within the terms of section 115 of the Evidence Act, minority estoppel 115 of the Evidence Act, which enacts a rule, the rule of estoppel, it would still be open to parties who had acted on a representation made by government to claim that the government should be bound to carry out promises made by it, even though the promise was not recorded in form of a formal contract as required under Article 99 of the Constitution. So representation is enough. And there are enough representation made by the government, and we have altered our position. And there is no question that they can permit it. And another thing, my lord, of course, it will not be relevant here, but I'll give you advance notice to Learned Advocate General, my lord. There is a decision from Calcutta High Court, which I have given in Manu. And in fact, there are 3 decisions. I'll place if required. My lord, the decision is in India Rayon and Industry Limited versus Union of India. I'm saying from Manu, and I'm sure copy must have been given to the Learned Advocate all these juniors.
No, Lordship, we haven't been given a copy, Lordship.
It's okay. Yes.
I'll just place paragraph 15 and 16. According to the series of Supreme,
yes.
According to a series of Supreme Court decisions, it is settled law today that doctrine of promissory estoppel would apply for affording relief in case of subordinate legislation. Their rule is subordinate legislation, my lord. Promissory estoppel will apply there also, though not to a legislature. But subordinate legislation is made by the executive, and therefore it will apply. That's what it says. And read it again. It is settled law today that doctrine of promissory estoppel would apply for affording relief in cases of subordinate legislation, at least when such subordinate legislation, so to speak, of the executive type, that is, where such legislation comes in almost from day to day, where the same is concerned with the levy of duty or imposition of tax on commercial issue or trade matters, which are continuing with a wide variety and scope of business activity. And we will not go further. I just want to show that even by amending the rules, if they want to bring it, will be again challenged. So my submission will be at this stage, my lord, that I have made up the prima facie case that I have a right, I do have a right to run the central bonded warehouse and to supply IMFL, etc., to all the bonded warehouses, 45 of them, under the rules as well as under the contract, and therefore I have right, and that right is threatened to be invaded by the government, and therefore I have come before your lordship.
Yes. Thank you, Mr. Mishra.
My thought would be that your lordship will extend the interim order.
Yes.
Your lordship
And
has to hear me, my lord.
Let me just, I'll take just 2 sentences. After that, I'll ask all the field with you. So my submission would be, my lord, that your lordship will extend the interim order. Otherwise, what will happen? They will violate our rights. We'll have to come back again. So your lordship will restrain you. Already your lordship has passed an appropriate order to maintain a status quo. That is status quo order to be maintained. And your lordship may hear it in detail. Well, I have cut short. There are many things which I have to place before your lordship.
Only on the interim matter, yes, regard to continuance. Yes. Yes, Mr. Advocate General, anything or you...
Your lordship, I have to, because so many arguments have been advanced by learned senior counsel in this matter.
Yes.
But the core issue which is before your lordship, with all due respect to learned senior counsel, is that core issue is that first, whether there is any legal right which is vested in the petitioner under the Act, rules and regulations. That is
no, see, one thing, Mr. Advocate General, just to the establishment of a prima facie case, that's all. Now, the thing is that, if I understand correctly, what Mr. Mishra has argued is that it is not necessary that a right be infringed, explicitly. Threatened action also will enable them to come to seek a remedy. And so, and the circumstances which are, circumstances which are there in this case are such that, looking to the facts, that the contract that entered into the tender and the entire policy decision of the state government does not allow at this stage even for you to contemplate, a creation of other. Yes, that's the thing. Yes.
The issue is, my lord, that before you threaten somebody's right, you have to show some right.
Yes.
What will I threaten when the person is not vested with the right? That is the second limb of the submission. First, you have to establish the right, then you will go into the threatened aspect. If you do not have right, can you come to the court and say that give me injunction and I am entitled to ad interim injunction? First, the foundation of any ad interim injunction is prima facie case. And what is the prima facie case, my lord, as per the petitioner, my lord? That there is a tender, there is an NIT, there is a license, and some affidavit. These are the all I can, if I summarize, my lord, that this is all they are saying that they have right under those documents. Now, if your lordship will see, first their right has to come from law, because first law, and there is nothing in those documents also. I will demonstrate from those documents that at any point of time we said that we will create sole central bonded warehouse in the state of Meghalaya. Rather, the terms of those documents are against the petitioner and they do not make any kind of representation or promise. That is the core issue, because first they have to show under the law that they have the right to do it. Secondly, if they do not show anything in law. There is nothing in those documents also there is nothing, my lord. Your lordship kindly have those documents one by one. Or before that, first your lordship will see, and then I will go to the threatened aspect also, because first foundation of any right is right law. Then only your lordship will exercise.
Not right law, right under law.
Our law, right? So I'm grateful, my lord.
Yes.
I stand corrected. Right under the law. And if your lordship will kindly see, first Excise Act.
Assam Excise Act.
Yes, my lord. 16, section 16. What I can do, my lord, because they are all fragmented. What has happened, my lord? Excise. These are all fragmented. I can do, my lord, I can prepare a compilation of in one place. Act, bonded warehouse rules, excise rules, all relevant judgment marked, and with note, my lord, your lordship may have it at the end of the board tomorrow, so that I can give everything, my lord. Then your board will be, because Mr.
Only one thing, Mr. Advocate General, tomorrow this court won't be available.
So your lordship may have it on Monday.
Monday also won't be available.
Oh my God.
So they will have it on Tuesday.
Tuesday, lordship.
Yes,
I will give the lordship part. You will make it part of the lordship.
Of course.
May have it on.
We'll conclude. Yes, we've heard Mr. D.K. Mishra, Learned Senior Counsel, on behalf of the petitioner on the prayer for continuance of the interim orders. The arguments in this respect have been concluded. Learned Advocate General, in replies, praise have been allowed 2 days' time to prepare a composite reply. List the matter on 11th March 2025. Stop interim orders continue the next date.
Until further orders.
All right.
Yes. I've argued the whole case. Thank you, Mr. Shays.
Item number 3.
You joined the file?
Yes, Your Lordship, and the last date file.
That 420 is for it's in the hearing column.
Yes, Your Lordship. No, Your Lordship, it's at item 8.
So what's 420?
Your Lordship, the state is yet to file an affidavit, Your Lordship.
You're for the petitioner. Item 8. This item number?
Item number 3 and 8, Your Lordship, they're connected. Why is it not connected? It's very much connected.
Lordship is pleased to take item 8.
Yes.
I have filed an additional affidavit.
Yes.
core issue, Lordship, is that a special committee has been approved for the school.
What special committee?
Special managing committee.
Where's
Your
the
Lordship,
affidavit?
in item number 3, Your Lordship, they have prayed to approve the ad hoc committee, Your Lordship. The ad hoc committee which was cancelled, Your Lordship. In the meantime, a special committee was constituted. Now, in item number 8, they have challenged the constitution of that special.
You challenge constitutional special committee.
Yes, Your Lordship.
Please to see my additional affidavit.
You withdraw the earlier one then.
I have nothing to do with it. If only
Then why is the same petitioner? Who's this Anwar Hussain?
he is a parent of me.
And Estamur Mominin?
And nominated SMC member, President.
You're just a parent. Then
Grievance is that
you have a child in the school.
that's I have
Positive about that.
yes, yes. My
You know the one case came for this court where
I know it.
where the petitioner said that I'm the parent of it, and found out this, then the affidavit filed that he was not a parent, and what did he do when adopted some child from the school to sustain his case? There's the limits.
I made it very only if Lordship is
That's your case, right?
no, that's not. If only
Mr.
Lordship
Day is espousing the grievances of the petition of these first matter,
Lordship, this entire
Same on the same ground. You on the same side, or are you at cross
I am
purposes?
saying, Lordship, that this school is without a regular managing committee for the last 5 years.
Right.
Sometimes there's an ad hoc committee that is cancelled. Sometimes there's a special committee.
So for you as a public spirited citizen, as a parent, you want that there should be proper elections by responsible engineers.
And in fact, government has passed an order. If Lordship is
Then is the effort necessary from the part of the respondents in item number 8?
they have
Why not file
Your
affidavit?
Lordship, because yesterday they had filed an additional affidavit. They have brought on record to
Okay,
Your
fine,
Lordship.
yes. In this case, you filed rejoinder.
Yes, Your Lordship.
Yeah, item number 3, MS.
pleased to see my additional affidavit for a moment.
Let's pass order number 3 first. Yes, I said, what rejoinder has since been filed by the writ petitioner. The this matter is ripe for hearing. Yes, we listed together.
Yes, Your Lordship.
Listed together with WC number 420, right, of 2024. Yes. Now come to your 8. What do you want?
Only Lordship may kindly produce my additional affidavit. Annexure 1 at page 6. Lordship will kindly see this is an order by the government itself. If I may just read, Lordship. With reference to the letter on the subject cited above, you are directed to ensure the formation of new school management.
This is 8 October 2024. What happened after that?
Thereafter, the Lordship will see the language of this letter. They have very clearly said, Director, that to constitute a SMC by
That'll be released, yes.
procedure within 1 month. Now, what they do is, Lordship, on 14th October, they have approved a special managing committee. And that managing committee is functioning till date. We don't know, Lordship.
So fine, anyway. We listed here in this matter. Mr. S. Deb submits that an additional affidavit has been filed, bringing record the fact that since 8 October 2024, the respondent number number 3 had directed for the formation of a new school management committee within 1 month. So I submits that this was not adhered to, and instead a ad hoc committee was a special management was constituted. This fact is noted. Yes. Next paragraph.
Praying for some time, Your Lordship.
MS Ailingwa.
Have to take instructions.
What about Dr. Mozika? Yes, sir.
Number 5.
Yes, it's urgent the matter then. Please without some more time to file affidavit in view of the additional affidavit just been filed by the petitioner. Accordingly, this after 2 weeks. Yes. So. This other matter together.
Item number 4.
Wait, please, Your Lordship.
Yes.
Wait, please, Your Lordship. Your Lordship, respondent number 1 and 2 and the pro
You
forma.
already filed the rejoinder.
Your Lordship will be filing the rejoinder in the course of the day, Your Lordship.
On behalf of
On behalf of the petitioner, Your Lordship.
to the affidavit filed by
To the affidavit in opposition filed by respondent 4 and 5, Your Lordship.
yes, your name.
Beelingdor, Your
Beeling
Lordship.
Moplang.
Yes, Your Lordship.
MS Beeling Moplang, Leonard Council Petitions submits that the affidavit, rejoined affidavit to the affidavit file 1.5 will be filed in the course of the day. This matter for hearing and so on so.
Your Lordship, we've not received affidavits from Respondent 1 and 2 and the
Not filed. Who's 1 and 2?
I'm for Respondent number 6. We are not filing.
1 and 2?
We are more or less supporting the case. However, my lord, I am praying for me. It is ready now.
You should see that the POM auto, the file the course of the day stop further. Mr. KB Barachaji for response 1 and 2. However, Mr. Please for further 1 week's time to file affidavit on behalf of these respondents. What about you 4 and 5? You already filed. You are? Number 3, who are you? You won't file? Yes. Mr. Rinja, on behalf of respond number 3 submits that a report has been filed. Such affidavit will not be necessary. Correct. MSPS number for number 6.
Respondent number 6, Your Lordship. We are not filing.
No affidavit forthcoming from this respondent. Submit after 2 weeks for affidavits by 1 and 2. And for further orders, yes.
Item number 5.
Please, Lordship, as per the last order, I have filed my rejoinder, Lordship.
You filed it?
Yes, Lordship.
Very good.
It will go for hearing, Lordship.
For disposal now, today?
No, Lordship, maybe can be posted
What's
for
the
hearing.
pension?
Regarding pension.
Then why you want to wait? Yes, what do you say?
We'll listen for hearing, Lordship.
When did the petitioner retire?
Actually, he was retired because mother
Died
not
in
retired.
harness?
She died.
You ready the matter? No.
Actually, I'm ready.
Mr. Bishan submits the joint files. This is a matter for hearing on so and so.
Item number 6.
Lordship, in this matter, as for the order 12/2/2025, I filed my application to implead this.
Where's the application?
It is there, Lordship.
Miss case number 33 or 2025 in notice of 398. This is an application filed for impleading the opposite parties herein, namely Sansu Mumin.
Yes, Sansu Mumin. Actually, is a representative daughter. Actually, her daughter was nominated Miss Amisa. Don't know, but she's still minor. That's
Still a minor.
Yes.
To substitute the opposite parties, namely Srimati Sansu Chechmohan, pin number 1, who stated to be the mother of so and so, who's still a minor, and Srimati Lorena so and so. The still not objected to by learned G.A. Conley. The 2 respondents shall stand impleaded in the minute petition. A respondent number
it will be 5 and 6.
5 and 6. Registry to make the necessary corrections. This case allowed and disposed of. In the main case, in view of the order, as per the order, in view of the order so and so, parts of this case so and so, registry to correct the cause title. Stop a petitioner to take steps on the newly impleaded one within 3 days.
Lordship. Deeply obliged, my lord.
Yes.
Item 7.
So number 1 may be represented by Chisla Minor.
Your Lordship, in item number 7, I pray for 2 weeks' time, Your Lordship, as the petitioner is having some personal difficulty.
Who's the petitioner? How many times you asked for time?
This is the second time.
The second time. MS beating the place for allowed further 2 weeks time for the joinder. This thereafter and so on. Yeah.
You will oblige.
Item number 9.
On behalf of respondent number 1 to 4, I'm praying for 3 weeks. We have not received instructions till now, Lordship.
Your Lordship, for respondent number 7 and seeking some Lordship.
Yes?
Respondent number 7, I'm seeking some more time to file.
You're appearing for 1 to 4.
1 to 5.
Correct, you're seeking time.
Lordship.
For 7 also. What about the state of service on 5, 6, 8 and 9?
Lordship, I'll be filing my affidavit of service because all of them have
They all been
received-
served?
Yes,
You're
we have
sure
served
about
it.
that?
Yes, we have just put the
Mr. P.
application.
Sama submits that please am allowed to file an affidavit indicating service on the respondents 5, 6, 8 and 9. Stop.
Lordship.
Next paragraph, Mr. S. Deb on behalf of 1 to 4 and MS SD Sangma on December 7, pray for and allow for a 2 weeks time to file their affidavits. This after 2 weeks for affidavits and for just after 2 weeks, yes, for further orders.
Item number 10.
Receive a pleading are complete. Receive. Let it post for hearing.
Just receive.
Receive what? Rejoinder?
For respondent number 4.
You received rejoinder affidavit?
No, Your Lordship, I have
Why
received.
Why you don't serve them?
I will file. Unless serve. Your
You
receive.
file, it's been
I
filed.
only file your receive.
When you file rejoinder?
I filed
Today?
yesterday. Your receive.
Okay, yesterday?
Yes.
Yes, sir. Mr. T. Nyota submits that the rejoinder has since been filed. Stop. You receive a copy. Your for respondent number?
Number 4.
Your name?
Okay.
The Secretary of Some submits that a copy has been received. However,
Lordship, I'm for the
for the
respondent
official
number 1 to 3,
respondents,
Your
a
Lordship.
copy yet to be served. Stop. Petition serve copies on respondents 1, 2, 3. List the matter for hearing thereafter. And so and so.
All right.
11.
Lordship, we have, may I please your Lordship, we have received partial instructions, Lordship. We are awaiting from the remaining respondents.
What is the partial instruction?
Partial means from only from one respondent, Lordship. We are awaiting from Kolkata,
When was
Lordship.
this filed?
Yes, Your Lordship.
When was this matter filed? 11th. Okay. MS Engineer on whose behalf you receive? Only from Meghalaya, from Shillong.
Lordship from Shillong. We are awaiting
Mr.
instructions
MS
from
NG Shilla
Kolkata.
Landed Senior Government Advocate submits that instructions on 4 and 5 shall awaited. Stop. She please for allowed further 2 weeks time to receive question to file affidavit.
Much obliged, Lordship.
Item number 12.
Edmund Charleston.
Yeah, please, Your Lordship. Your Lordship, I'm praying for some time, Your Lordship, on behalf of the state respondent.
Yes. What's the matter about?
Your Lordship, this matter pertains to the non-regularization of service from the date of my initial appointment, Your Lordship.
Okay, MS Ailangma please for allowed for a 2 weeks time to file affidavit. This thereafter and so on. So.
Much obliged, Lordship.
Item 13. 13.
Lordship, affidavit is ready. We'll just give it in course of the day, Your Lordship. We're waiting for the signature of the officer.
You only government respondents.
No, I'm for the
Any
petitioner,
federal
Your Lordship.
no. Only government respondents in the matter.
Yes, only the government respondent.
Okay, MST Yangi, yes. Then EAG is also appearing for all the respondents. Submits that after to be filed in the course of the day. This is a matter of after 2 weeks for rejoinder if any. Yes. You already receive a copy?
No, I haven't received a copy.
Item
14.
In this case, Your Lordship, we need some time.
Yes, Lordship.
Yes, 14.
Me, I submit a small submission, Your Lordship. This petition, Your Lordship, has suppressed the entire material fact by not disclosing the fact because the petitioner have resigned from the president and secretary from the post. Thereafter, after their resignation, the BDO have asked them to.
Well, firstly, please clarify who you are appearing for.
No, I'm for the respondent number 4 to 6.
So you accept notice.
Yes, I have accepted notice and
So
that-
first, then you enter appearance first. 4 to 6, fine. Mr. P.T. Sangma today has entered appearance on behalf of respondents 4, 5, and 6. As such, notice complete all respondents. Yes, what do you have to say?
No, yes.
That is, you have to mark your appearance.
Yes, Lordship. Yes, sir.
Yes.
Now what happened is because they have resigned from the post of
BC.
president, yes, secretary. Thereafter, the BDO have notified for fresh election. The reason for resignation is that First, the petitioner, they have forced the signature of all the villages, the job card holders, and they
forged
have
all the signatures?
yes, it is there. Then they have submitted to the PDU, and after with the forced signature, they were approved as a president and secretary. Thereafter, the job card holders, they have filed the FIR against them, and later on they compromised with the police station, and after the compromise they have withdrawn, and their compromise signature, everything is there, and now they are coming back and saying that they won the election.
If I put an affidavit,
yes, Lordship, it is there. It is there. All the documents is there.
Yeah, put an affidavit.
Lordship.
He submits that the petitioner has suppressed material facts in approaching this court. He prays for result of place same by affidavit within 2 weeks. Yes.
Lordship.
Yes, up to 2 weeks. Yes.
Lordship.
For orders.
The state will also
State, similar prevail behalf of the state is allowed. But as a whole, is up to 2 weeks. Yes.
Most Lordship.
Hearing supplementary list item 3.
My lord, due to some medical emergency of a family member, Mr. Yobin has to rush back home, my lord.
To Arunachal Pradesh?
He went back home due to someone was sick at his place, his family member or someone. Yes.
Oh.
If it's convenient to my lord, if this matter can come up tomorrow, he will be there positively, my lord.
Next week, Lordship. Next week.
Maybe Tuesday, okay, that's fine.
Lordship, if I may, Lordship, the petitioner's appointment is under challenge in writ petition 425 of 2020, Lordship, on the grounds of illegality, Lordship. I pray, Lordship, these matters can come together.
Is that correct, Mr. Karmi?
Yes, they have mentioned in their petition also.
Yes, but there's no stay order regarding that.
What is your name? Sorry.
Edakhar, my lord.
Ms. Edakhar, on behalf of the petitioner, prays that the matter be adjourned due to the personal difficulty of Mr. Yubin. Stop. Mr. Where you're for number 4 here?
Lordship.
Why didn't appear last time? It's one ex parte against you.
I apologize, Lordship. I was on my legs on the other board. I missed, Lordship. Sincerely, Lordship.
Yes. Yes, Mr. S. Pandey, who is present today in House 104, submits that the subject matter issue is connected to.
That is regarding appointment. This is for payment of salary.
Yes, connected. Connected to the matter to the issues in WC number 425. He prays that the same may be destroyed. According to these 2 matters together up to 1 week.
17.
Yes.
Well, please, Your Lordship. Your Lordship, this matter I preferred, Your Lordship, because I was given prospective regularization of my service. Your Lordship, this matter before this Honorable Court, actually it's a second round of litigation. During the first round of litigation, Your Lordship, which was disposed of by order dated 10/9/2018. This is at page 11, annexure 2, my petition, Your Lordship. I've been directed to be given to accord due consideration to the case of the petitioner for permanent absorption as against the post he has been working right from the year 2004. So this is to give due consideration to the service that I've been working right from the year 2004. But at the time of giving regularization, Your Lordship, I've been given prospectively, and that is the order is at page 14, Your Lordship, whereby I have been regularized by this order dated 22nd October 2018. So, Your Lordship, my case here, Your Lordship, is very clear, because, Your Lordship, I have also annexed the list of other employees, similarly situated employees of the respondent, who were appointed on compassionate appointment, which is similar to mine. They were the annexure is at page 15, Your Lordship, annexure 4. These are employees, Your Lordship, who have been given regularization from the date of them joining the service. But in my case,
no, but they were given from the date of joining.
Yes, from the date of joining.
Because they were regularized on those dates only, 2002, 2004. You were regularized after 1918. Yes, one of them three, they were compassionate. See, just see the ones that from serial number 4. See, the 1002, they were given 1002. Because 1505, the DSC held, right?
Yes, Lordship.
Then?
So date of joining of...
There's not retrospective regularization.
They have been
How do you see this as retrospective?
For me, Lordship, in my case?
No, for these people who you've...
They have been given from the date of joining. That is my submission,
No,
Lordship.
it's not retrospective.
No, I'm saying that they have been given regularization from the date of them joining the service.
No, see, just come to this number 4. Okay. Compassionate ground, see, date of organization, 15/5002, date of joining, so and so. So the date of organization is 15/5. So they had served just for, they hadn't even served and they were, you know.
Maybe they...
I don't understand this.
On the date of... So this is
show me a case of post facto.
Provisional gradation list, Lordship. But the final list, let's come to the final list.
Just show a case where a person similar situated like you.
Yes, Your Lordship, I'm coming to that.
Compassionate ground as a few years ago, case considered thereafter, in a certain year, given retrospective realization the date of first joining, first appointment.
Your Lordship, if this particular annexure, it seems Your Lordship is creating some confusion. But if you go at the affidavit filed by the respondent, they are admitting the fact, Your Lordship.
You have to go on your case only.
Yes, definitely.
You can't build your case the weakness of the case of the respondents. You prepare the matter. You'll have to 1 week, yes. And you bring authorities on retrospectivization, especially on compassionate ground. Compassionate ground is not an ordinary appointment.
Yes, I agree.
This after 2 weeks in April, the council petitioner to come
if
out
Your Lordship
authorities.
may permit me, this annexure, this is
you just prepare.
Okay, Your Lordship.
You don't seem to be prepared well enough, yes.